112645, State of Kansas v. Josiah Bunyard.
May it please the Court, Mr. Chief Justice. My name is Richard Ney. I am appearing for the appellant Josiah Bunyard. Mr. Chief Justice, I'd ask for 3 minutes for rebuttal.
3 minutes is granted.
Thank you. In brief summary of this case, Josiah Bunyard was convicted of 2 counts of aggravated battery against Jennifer Wood and also a violation of a PFA and intimidation of a witness also against Jennifer Wood. Those were joint cases. At the beginning of the trial, or actually the Friday before trial, Mr. Bunyard asked that he, quote, unequivocally be allowed to represent himself. The court did not take that up further, either on that day or prior to trial. During the trial, instead of evidence being presented directly from Ms. Wood, her preliminary hearing testimony was provided to the jury because the court had found that she was not available and overruled an objection on that ground and overruled the objection on the ground that the attorney who had questioned her at the preliminary hearing had an actual conflict, that he was also her attorney. At the end of trial...
Mr. Ney,
yes.
I know you're kind of doing your factual recitation.
Okay.
But I want to put a bookmark there
Sure.
on the conflict, because I'm confused about it. If you want to finish your factual recitation, then we can talk about that first.
Well, my time has started, so
okay.
I'll go.
Alrighty.
You had asked about what the conflict was.
I find the record very confusing on what the nature of the conflict was. And that hurts you, of course, because without being able to demonstrate what it was, then it's pretty hard to know that it hurt your client's interest. So if any way you can enlighten me or make that a firmer piece of information would be very helpful.
I will attempt to, Your Honor.
Okay.
And let me get to that. At the time that the conflict issue was raised, the prosecutor gave a summary to the court of what the conflict was, and I'll quote it. This is from Record 1, pages 2, 67 to 68. My understanding was the conflict was that Mr. O'Hara had previously represented or was planning on representing Ms. Wood, or in another sort had represented Ms. Wood, thereby creating this sort of conflict that Mr. Sievert's alluding to, where Mr. Bunyard wouldn't have had the benefit of full representation. So the state says he's represented her before.
But the letter from O'Hara talks about the representing a Mr. Ivey being the reason for a conflict.
I understand, but that's what was put on the record. So okay. I'm going by the record, okay, which is what the state proffered. And then the court said, importantly enough, and this is a quote from the court, at a later point in that hearing, if he made a withdrawal based on a conflict, that issue's been dealt with and the withdrawal is allowed, I don't think I need to address the validity or details of that conflict. So the court has said, I'm accepting what the prosecutor said, and that's good enough for me, I'm not going to address it. So in a sense, the confusion on the record, if it exists, is due to the court not exploring it and accepting what the state had said. So I think that's where we are on the record.
Okay.
On that issue.
Okay.
Mr. Ney, on
yes.
on the self-representation issue, you had said that the district court never took up the issue again after the Friday. Now, as I understand the facts from the Court of Appeals decision, was they broke for the weekend, and when they came back after the weekend break, and there was some discussion about the defense attorney meeting with his client and having some more discussion, then there is something on the record, according to the Court of Appeals, where the attorney says, we've talked, here's how we're going to handle X, Y, and Z issue. I think the district court even asked. Then he did ask, or the judge did ask the defendant, is that satisfactory? And the defendant says something like, well, we'll see if he does what he just said he was going to do. my point is that is an inquiry about this subject, it seems to me. Now, whether it's an appropriate inquiry, I'll set that aside for a second, but at least we've got the issue back in play on Monday or Tuesday morning, whatever day that was, but after the weekend. Am I right about that conversation occurring?
I agree there was a conversation with counsel. You know, have you talked with him? Yeah, we've talked. And then Mr. Bunyard says, well, we'll see what happens. But we have to go back to Friday, Your Honor, because I think that's the critical point. Mr. Bunyard says, and this is his quote, I unequivocally want to represent myself. Now, the Court of Appeals found that equivocal. He says it repeatedly. He says, I want to be heard on this. No, I don't want to hear from you now. No, no, no. 3 times. And in fact, we know how this ends. Finally, the court guard says, do you want me to take him out of here? Now, I don't know how more aggressive a defendant needs to be to say he wants to represent himself.
I guess where I'm getting with this is I personally liked the way this court handled in the Pfannenstiel case on when a client blurts out a dissatisfaction with their attorney, and we said, well, there needs to be an inquiry, and then here's kind of the way you handle it. Now, we haven't said the same thing, we haven't addressed it on self-representation, but I kind of like the steps that we used in that context and thinking that they would be appropriate in this context. I wondered what you thought about that.
Well, you have addressed it, I would say. The Van case addressed this very issue. When it's raised, this court has said, in Van, got to be dealt with. Just the court ignoring it and just moving on and the counsel representing the defendant afterwards does not resolve it. And Van required a reversal. So I guess, Your Honor,
where I'm trying to take, this is an easy
Right.
discussion when it doesn't come up again. I'm trying to deal with this after the weekend discussion where the judge asks the defendant, is this arrangement satisfactory? I'm not saying it's good enough, but it seems like it's different than just ignoring.
Well, it's depending on what he's talking about, I guess. Because he never says, have you changed your mind? Do you want to represent yourself? He talks with Mr. Sievert, the defense counsel, and says, you've talked with him about these things, the motions and the things that are pending. And that's what they're talking about, not representing himself. And then he says, is that good enough? And so my statement to you, Your Honor, is I don't know that the defendant would take that as going back to the issue that he raised repeatedly, unequivocally, I want to represent myself. I think the onus is on the court to clear that up. And it never happens. And that's the problem here. And under Van, that's a reversible error. I agree. Even the Court of Appeals said, well, this wasn't the most artful use of the judicial discretion here and how this was handled. I'd second that, but go beyond that and say it totally obliterated his rights. And let's remember what happens later in the trial. Mr. Sievert says, okay, now time for the defense. He says, I'm resting without presenting any defense, or any witnesses. And the defendant says, oh, wait a second, I have these 20 witnesses I want to present. So there clearly is a problem. So saying it worked out, whatever that meant, it hadn't. Because he was still trying, Mr. Bunyard was still trying to represent himself and saying, I have these witnesses. And they were never called.
Didn't at some point, and help me understand where this occurred, at some point defense counsel represented to the court that his client was refusing to even discuss some things with him until his request for self-representation was acted upon by the court.
That was motion for new trial.
Right.
Was that after the trial? That happened after?
Yeah,
That was
after the trial, and one of the
Okay.
issues we raised, Your Honor, was the fact that Mr. Bunyard asked for now
Right.
a
Okay.
new
Yeah.
attorney.
I was just needed clarification as to where that happened. Thank you.
And he
Mr.
says,
Nay, I have another question
Yeah.
related, if we can go back to Van for just a second
Certainly.
before we leave it totally. There was also, as I recall, in that case, not just a failure to address, but actually placement of obstacles in the path of assertion. of the right to self-representation. And isn't it also your position in this case that that's what happened here? It was like, I hear you put it in writing, which was more difficult than it might have been for this defendant because of the weekend situation. This defendant has certainly demonstrated capability of filings,
Right.
getting filings done.
Right.
You want
well,
to address that?
Yes, I'd love to. The court, when Mr. Bunyard is trying to address this, 3 times says, Mr. Bunyard, we're not addressing this matter further, period, stop. I mean, that's what he's saying to him on Friday. We're not addressing it further. But then he says, and the court is right, we're not going to address it this time, and he says that you have to file a motion. And Mr. Bunyard says, the court there's no mail going out for the weekend. There's no way I can get it in there. Remember, this is Friday afternoon, I believe, but at least it's Friday. He's in jail. Trial starts first thing Monday morning. That's the record. How does he get this written motion in? And frankly, Van says that's absolutely not necessary. Under the law as it exists and as it existed then, this court had said that's not necessary. Once this is raised, the court has the responsibility, not the pro se defendant, or attempted to be pro se defendant. So absolutely there are obstacles. And I think a court guard telling you to sit down and shut up when you're trying to say, I want to represent myself, is an obstacle too. Mr. Bunyard has learned his lesson that he can't raise this again, as the court said, without a written motion.
Could the trial have proceeded on Monday with pro se representation? Let's just say the district court did address it, said, okay, I'm going to give you this kind of caveat here. This is not a good idea. The thing that typically happens when a defendant asserts his or her right to represent themselves, says, we're okay. Did the judge then have the ability to say, okay, we're starting Monday, you're representing yourself?
At least he could have told the defendant that. And I believe Mr. Bunyard had said he wanted to proceed. He was not asking for a continuance.
Right.
So I think the answer is yes.
On the subject of that, later we know the judge indicated a willingness to continue, right? Because of the response to the motion for discovery. The judge offered a continuance as an option to the defense on Monday morning when they demanded to get the computers and cell phones. Isn't that right?
Yes, that's correct.
Okay.
And Mr. Bunyard was not looking for a continuance. I don't disagree
No,
with that.
he declined it, which causes him a problem on that issue, obviously.
Well, I mean,
Potentially.
Potentially, yes.
But it tells us something about what was in the judge's mind about flexibility to continue. For judges, district judges, understandably, are reluctant overall to continue cases at the last minute when it looks like it might be a ploy of some sort. But here, the judge offered a continuance on that issue.
And it clearly wasn't a ploy for a continuance. Mr. Bunyard wanted to go forward. He wanted to go forward pro se. He had subpoenaed 20 witnesses, as he said on the record, that were never called. So there is, in fact, a factual piece of that there. If I can just deal with one other matter quickly, it was brought up by Justice Siegel about the request, say, I don't want this attorney, I want another attorney. Let's understand what happened at sentencing. Mr. Bunyard had filed a disciplinary complaint, a malpractice lawsuit of some nature against Mr. Sievert, was complaining vigorously about him in requesting a new trial, and Mr. Sievert was asked, is there a conflict? He says no. But if you look at the record, Mr. Sievert is saying how Mr. Bunyard is not trustworthy on these points. So we have counsel, if you look at this court's jurisprudence under Sharkey, that is completely conflicted, and frankly, as this court said in Sharkey, is no counsel at all. Even if Mr. Sievert says, I can proceed, he is acting against his client, because when the court asks him things about Mr. Bunyard, is this true, is this not true? No, it's not true. It's not a great position to be a defense lawyer telling the court just before sentencing your client is a liar. And that's what happened here.
If we agree with you that this should get remanded for a new trial, do we even get to the other issues? Especially if they try to utilize Wood's preliminary testimony, I guess that's just an issue for the next trial.
It is, Your Honor. That's correct. Obviously, if you decide self-representation was violated, there really is no need to deal with these other issues, which will be dealt with again.
Just in case we don't, I really need to understand what you're doing with the Brady claim,
Yeah.
because
Yeah.
this just doesn't look like Brady to me. It looks like it might be something else. I'm not sure what. Maybe something we haven't talked about ever before. But it's not really quite Brady, because we don't know that there's anything, really. We
Well-
don't know that there's anything. So go with me here for a second.
Mm-hmm.
So if the state somehow prevents the defendant and his or her counsel from doing the investigation necessary to prepare their case, that'd be some kind of problem. I don't know what we call it, but I don't think it'd be Brady. Brady is when you know there's something exculpatory in the possession of the state and it's not turned over. And you have the 3 prongs you have to meet, and it looks to me like you've got problems on prong 1 and 3. So it doesn't look like Brady to me. But what would that be? Just some kind of generic due process violation? Because what we have here is we've got another case. The state's taking computers and cell phones, is just hanging on to them, apparently indefinitely, hasn't sought a search warrant to go into them, but they're unavailable for defendant and counsel to peruse and see if there's anything useful. So that to me seems like a problem, but it doesn't seem like Brady. Now, I think you have another problem on harm, because he was offered a continuance so that they could look through them, and he turned it down. So can we just talk about that issue and tell me what we're dealing with?
Absolutely. Is it a generic due process violation? I don't mean generic, but is it a due process? Certainly. Is it Brady? I'd argue yes, it is, because this is his phone and his computer, and he knows what's on it. And the claim made was there's helpful information there, but I can't get to it. So is it Brady? Yes, I'd argue it is, because he knows. Now, how could we have found out for sure and had all this before, Your Honors? I filed a Van Cleve request with the Court of Appeals.
Which is usually about IAC.
Well, usually is, but we have an issue here that I frankly think needed to be fleshed out. I think there are a number of issues, but this was clearly one of them. And the Court of Appeals said, well, we don't know what was on there, so how can we, and our response to you in our petition for review is, we didn't know because you wouldn't give me the Van Cleve. And the intent was to go back, take a look at that and say, aha, see, here's what it is. And again, Mr. Bunyard had been through a couple of lawyers.
Let me just,
Yeah.
because that sounds like
Sure.
both sides of your mouth. He
Well-
knew what was on there.
Yeah.
So could he not have provided some more specificity about what the Van Cleve was designed to flesh out? I mean, it seems like you can't have it both ways on that. He knew what was on there, but he didn't know.
Well, I mean, he had always said he wanted it because it was helpful to his defense.
Yeah. Okay. All right.
And
just
I
think
don't-
it's-
you know,
I
and
think
we
it's
all-
just not a perfect Brady.
Well, it wasn't. And I think a Van Cleve would have certainly helped us, but we were handcuffed on that.
Okay. Thank you.
I see my time is well up.
Any more questions? Do you need 30 seconds to wrap up?
I do not, Your Honor. I'll
See you
come
on
back in
rebuttal.
rebuttal.
Very good. Thank you, counsel.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I intend to focus primarily on issue 1, and of course we'll be happy to take any questions about the remaining issues.
Maybe we can get a couple of them out of the way real quick.
Sure.
Do you have a version of what the facts are on the O'Hara conflict?
I do,
Okay.
and not surprisingly, they differ slightly from Mr. Nay's. He is correct that at the discussion about this, that the prosecutor did make a reference to the fact that he thought that there was some indication that Charlie O'Hara had represented or would be representing the victim. But I think even by the language that Mr. Nay used in quoting that passage, it's clear that the prosecutor was uncertain. The prosecutor.
He was spitballing.
Correct.
Okay.
What we do have clarity on is the letter in the record from Charlie O'Hara to the defendant in this case. Now,
Who was that guy?
I guess I will answer that. The other thing I want to focus is I would submit that it's reasonable to believe that Charlie O'Hara had a better basis for knowing what his potential conflict is than somebody else. And in that letter, he specifically says that the potential conflict is because he had recently recalled that he had represented Gary Ivey. Now, what we have in the record about Gary Ivey is not a ton of information, but what we do have suggests that Gary Ivey is somebody who, in another unrelated case, Mr. O'Hara had represented. There's also an indication that perhaps Mr. Ivey was a victim of an assault committed by this defendant. However, the record does not indicate that Charlie O'Hara's representation of Ivey was at all connected to the case in which the defendant had this action against Mr. Ivey. So I would argue that by far the most clear piece of evidence that we have in the record is Mr. O'Hara's letter to his clients, where he very specifically lays out the conflict. And I would further note, and this ties into comments that I'm going to be making with respect to issue 1, is that this defendant himself, at the post-trial hearing, and when he's filed the motion where he's asking for a new attorney for sentencing, his complaint to the court, and part of his complaint to the court is, I wish Charlie O'Hara had represented me all the way through. I don't think there was a conflict. So we have the defendant himself telling the court, the trial court, that he does not believe that there was any conflict whatsoever with Charlie O'Hara. Now, obviously, the defendant is not a legal expert and might not know exactly what constitutes a potential conflict of interest. But I do find that telling that the defendant himself took a position, a very adamant position before the trial court that is diametrically opposed to what he's arguing on that issue on appeal. And where that ties in with issue 1, I think, is that this shows a pattern of behavior by this defendant. Quite simply, the record, when you look at it in its totality and in reality, is that this was a defendant who, like, unfortunately, many criminal defendants, he wanted to have it both ways. He wanted an attorney representing him, and yet he also wanted to be able to dictate every strategic move that those attorneys made. And that is what brings us to the Friday before trial. Basically, the defendant was unhappy because he didn't think something was being argued the way that he would have preferred. And so he interjected himself into the discussion that his attorney was having with the court. And that's when Judge Magana did tell him, look, you've got an attorney, so I'm not going to listen to you make these oral statements here as long as you have an attorney. And I will admit, as the Court of Appeals did, Judge Magana certainly could have handled this differently, and he probably could have handled it better. But essentially what he's telling him is correct, in that you can't have hybrid representation. You can't continue to argue things pro se if you've got an attorney here. Now, he did, at one point during that hearing on Friday, he did make the statement about, well, I'm not going to take this up right now because you've got an attorney, and if you want to be heard on your motion, on a request for pro se representation, then you're going to need to put it in writing, and I'll consider it at that point. However, I think that when you look at what happened as a whole, you'll see that on Friday, when first of all, as the Court of Appeals, I think very importantly pointed out, this was a defendant who was very prolific in filing pro se motions and advocating for himself. Yet the defendant himself had never even broached the topic of pro se representation. It wasn't until Judge Magana told him that he couldn't continue to argue on his own behalf when he had an attorney, that's when this whole...
I understand that makes for some doubt, perhaps, about his sincerity. But honestly, can we really do that up here on appeal? I mean, can we say, oh, it just looks like he was gaming, when he says on the record 2 times, I want to represent myself, and then the second time he says, I unequivocally want to represent myself? I mean, the timing was grossly unfortunate.
I think you can. I don't think there's anything about this court's role that requires it to check common sense at the door and look at the totality and see. And I think that's exactly what Judge Atchison did in one of the other issues with respect to the alleged conflict post-trial is say, look, the defendant, and the exact language that he used was, the defendant engineered a situation which he then tried to say created a conflict. And I think Judge Atchison very smartly looked at the surrounding circumstances to realize that that's what was happening.
Aren't you permitted to engineer a situation in which you can avail yourself of your right?
You can, and
if he's availing himself of his right, what does it matter?
Well,
whether
first of
he
all,
engineered the situation.
I don't accept the premise that he did avail himself. I think that on Friday, his first two statements were in response to questions, and those were anything but unambiguous or unequivocal. Those, he said, well, I guess if that's the choice, I'll represent myself.
Well, really,
Now, the
I mean,
later
that's
states-
against the engineering sort of gloss on this, because it was offered by the district court. I mean, it wasn't his idea.
Well, he
at that
engineered,
moment.
I guess what I mean by that is he engineered it by setting this whole thing in motion by standing there and trying to second guess his attorney's job in arguing the motion about Woods' unavailability. And by getting up and saying, I want to be heard, that's what set this whole process in motion. Now, you are correct, and counsel's correct. On Friday, after the first couple of statements, when the court then took a recess and allowed the defendant to think this over and speak with his attorney, that's when they come back on the record, the defendant uses the word unequivocal. I unequivocally wish to represent myself.
And what more did the defendant need to do that Friday so that right would have been observed?
Nothing. And I think this is where my argument is. I want to make sure that I make this clear. If what happened Friday was that he had said that, and then court had recessed for the weekend, and trial had resumed back up on Monday morning, and if there had been no further inquiry, no further discussion about this, and the first thing that happens on Monday is we're on the record and the defense counsel's there and we're picking a jury, then I wouldn't be standing here today arguing that that was not an error by the trial court.
And counsel, just right at this stage, before you get to the Monday morning conference that I talked about, which is where I presume you're going, you would agree that the U.S. Supreme Court says that a violation of this right is not subject to harmless error analysis?
Yes,
At
if a
this
defendant
stage.
has truly invoked the right to self-representation, then that is structural error if the court does not.
And you agree that when they left for the weekend, the court had erred, and that's structural.
No, I don't agree that he had erred because it was an ongoing proceeding, and that's where I think that a lot.
Well,
But he made
If
wait.
that had not continued,
right. That's all. I
right?
know.
Yes, if that was the end of the proceeding,
Right.
and yes, but that's where I think we have to. We can't look at this as if Friday was the totality of what happened.
So it's okay to talk him out of it? Because I think
I don't
that's
think the
where
court
you're
did
headed.
talk him out of it.
Maybe his
The-
lawyer did over the weekend. I mean,
Well,
something
that's pure
happened.
speculation.
Well, no. Okay. Why
It's-
don't you just tell us what you think happened on Monday morning first, and then we'll talk about
So
what
they-
might have happened in the intervening time.
It's not speculation to say that the defendant and his attorney spoke. That's clearly shown in the record that when they get back to court on Monday, their attorney very clearly says that they had time to discuss this. So
And
that's
can you direct me to the place in the record of just the citation if you have it handy? If you don't worry about it. This
Yeah,
is
with
Monday a.m. They show back up, and then what
yeah,
happened?
on Monday morning, this would have been record volume 3, starting at page 5, is
Thank
when
you.
the court stated that the parties had spent the morning in chambers discussing several outstanding issues. The court then noted that the defendant had all of these pro se motions that were still outstanding, and this is beginning on page 8, where there's this discussion between the court and the attorney, where the attorney says, essentially, my client and I have discussed these things. What we've decided to do is essentially withdraw the actual filed motions by the defendant, and instead I will just be arguing orally many or most of the points that he made in those motions. And then significantly, the court then turned to specifically address the defendant personally and essentially said, look, you file a lot of motions where you're basically purporting to represent yourself. You've had time to speak with your attorney about this. And talk about how you wish to proceed. The defendant confirmed that he had spoken with counsel, and then the defendant said that counsel would sum up the motions that were still relevant. And the court didn't just stop there. He addressed the defendant 3 more times, asking whether he no longer wanted his pro se motions to be heard and instead wanted counsel to make an oral presentation addressing whatever issues the defendant believed were still relevant. And each one of those 3 follow-up inquiries, the defendant again affirmed that that's what he wanted to have happen. So while counsel is correct that Vann and other case law does stand for the proposition that once a defendant has invoked the right to self-representation, he doesn't have to continually reassert it. That's a correct statement of law. But what counsel fails to recognize, and what I would argue, is that once you've asserted that right, that's not irrevocable. Once you've asserted the right to self-representation doesn't mean that you can't later change your mind. And in fact, I would argue that it happens a lot.
But you would agree that the record that what should have happened is the district court judge asking, do you still want to represent yourself?
That would certainly have been better.
And get on the record rather than have it implied.
Yeah, certainly it would have been better if Judge Magana had said, in addition to wanting to have your attorney argue these pro se motions for you, are you specifically telling me that you no longer want to represent yourself? Of course, that would be a much better scenario for making this.
If we're supposed to protect constitutional rights in this process, don't we have to insist that the judge's duty of inquiry includes getting a clear record which way the defendant wants to jump?
Well, I think that's what the court didn't do as great a job as he should have or could have, but I think that he did. I think that what happened on Monday did give us a clear record of what this defendant's intentions were. Again, this is where reality has to enter into the equation. I don't know how anybody could look at that record and say that the defendant is telling you, see this guy right here, my attorney? I want him to make an oral presentation to you guys on my motions. Well, how does that not show that the defendant wants to have his attorney represent him?
After he was told that the court would not take up his request for self-representation.
Well,
Did
that's
the
where
court ever
Unless
say,
it's in writing.
okay, what I told you on Friday, now King's X on that because I'll take it up now?
Well, I think by actions speak louder than words. He's telling you, all right, here we are. We're here again on Monday. You've had a chance to talk to your attorney.
But if the court wasn't going to allow self-representation, why does the fact that the defendant wanted his attorney?
The court never said he wasn't going to allow self-representation. He said that
not
on
without
Friday
written-
he wasn't going to allow the defendant to argue it that day without filing a written motion.
Not without a written motion. That's
Right.
what the judge told him. Not without a written motion.
Right.
And
So
he knew he hadn't filed a written motion on Monday morning when he's having this conversation.
And that's where my point is, actions speak louder than words. Regardless of what the court had said Friday, when he was obviously frustrated by this situation, when they resumed on Monday and things had calmed down, he very clearly was giving the defendant the opportunity to discuss this. And you have to
So-
also...
Van says you don't have to reassert.
Right.
So why was it the defendant's obligation at that time to reassert that?
He didn't have to reassert. My point is not that he failed to reassert. My point is that he, contrary to his prior... he changed his mind.
No,
He had
but
But
previously...
he had been
The,
told he had to
discussion.
reassert. I'm sorry. I didn't mean to
He had
interrupt.
been told to reassert, and
Yeah.
also the discussion seemed to be that, do you want your attorney to argue your motions for you? Not, do you want your attorney to withdraw and you do it? It wasn't so much in my mind that he was being told you can represent yourself. He was told that if he either withdrew his motions or his attorney would make those points.
Well, again, I think, first of all, you have to look, again, looking at everything that happened, and including the fact that the court noted that that morning, the parties had spent time discussing several outstanding issues.
And was that an off-the-record discussion or something?
Yeah, well, the court said what was going to happen right now is that it was going to put those off-the-record discussions on the record.
Okay.
Of course, whether everything perfectly gets placed
Sure,
on the record is
sure.
questionable.
But there'd been something going on among the
Right.
parties before they went on the record and you had the exchange you just described.
And I think to address a question I can't remember which justice asked about protecting a constitutional right and making sure that the court goes through the proper inquiry. I guess two responses to that. One is that the U.S. Supreme Court case law tells us that with respect to self-representation, that essentially every presumption should be made, while the defendant has an absolute right to invoke it, that every presumption should be made against it as far in before determining that a valid waiver has been made. And of course, the case law tells us that there's this long checklist that the court has to cover with the defendant before allowing self-representation. My point would be that in this case, we didn't even get to the stage where that long checklist was necessary, because before the court even needed to warn him about the inherent risks of self-representation, the defendant, in consultation with his attorney over the weekend, had come around to the conclusion that he did, in fact, want his attorney to continue representing.
Counsel, on that point, if we assume, I'm going to change the facts. Let's assume everything happened perfectly on Monday. A thorough colloquy, and you had a thorough renunciation of the request. Wouldn't there still be a problem, though, with what happened on Friday? Because what happened on Friday was that the court didn't just recess for the weekend. The court went on to take up and consider and rule on substantive matters. And isn't that, again, assuming something different than what happened, Monday is perfect. Don't you still have a problem with what happened Friday afternoon?
I don't know that we do. I guess two responses to that also. One, I don't know that we do. I think that because it involved a recess over the weekend, I think that might make it look worse than it actually was.
Well, I'm not talking about that. I'm saying what the judge went on to do after the invocation, what I'm going to say is the unequivocal request for self-representation. It wasn't that the judge just said, I'm not going to take it up now, we're going to recess for the weekend. The judge said, I'm not going to take it up for now, and then went on to do other things that were substantive in the case. Isn't that right? Issue rulings on the availability of the witness and the admissibility of the preliminary hearing testimony, et cetera, et cetera.
I think that's correct. My brief citing volume 2, pages 83, indicated that the court, it was when the court said that it was prepared to rule on Wood's unavailability, that's when the defendant interrupted.
And so even if the defendant wasn't denied his right to self-representation from Monday forward, what do we do with the fact that even if it is only that brief period, the defendant had asked to act as his own counsel
In that hearing.
and it didn't happen? Even if it was only for 30 minutes or however long that took.
Right. Well, I think a couple things. One is that by that point, the argument with respect to Wood's unavailability had already been made, and that was before the defendant ever made his unequivocal request.
But not before he'd made another request in which he didn't use the word unequivocal. I mean, he had tried to get some licks in on that too earlier in the hearing.
Yeah, he made
That
the
was
big.
his first invocation.
He made the
When he
somewhat
got the
ambiguous
option given
remarks.
to him by the judge, he said, well, in that case, I'll represent myself.
Right.
So, I mean,
And does the context of that tell us that he wanted to add to the argument but wasn't allowed to?
that's what his frustration, that was the source of his frustration right there. He just, I understand your frustration that this is a defendant who wants to run the show with a lawyer, but that's what he said.
Yeah, and I think that is, and again, talking about some of the other issues later in the brief, it does show that this is somebody, it wasn't just with respect to Wood's unavailability, it was with respect to, as counsel pointed out, this is a guy who has this long list of witnesses that he feels should be called. He thinks he should be able to dictate the course of representation. So, while again, I acknowledge that once you've asserted it, you don't have to reassert it. But
And that's the problem with Monday. That's the problem with trying to rely on implication for what happened Monday. I mean, a colleague down at the end of the bench has talked about another issue, which is what happened Friday afternoon post-invocation. But I want to return to Monday because you keep saying, obviously, he had changed his mind. Obviously, he talked to his lawyer. He had changed his mind because he wanted his lawyer to proceed on these motions on Monday. The problem is, even if he did change his mind, he'd been misinformed by the trial court on Friday afternoon about how to invoke his right. even misinformed. Had anybody corrected that misinformation before he changed his mind or implicitly changed his mind? We don't have any record that that happened, do we?
No, I guess my best response there is, obviously there are different degrees of, having to imply something or having to try and speculate as to what happened. If on Monday, instead of what really happened, if they had just simply started back up and no discussion about
mention.
any of this pro se stuff had happened, and they just began right in with defense counsel picking a jury, then somebody could try and make the argument that, well, that must mean that he decided he was okay with his attorney representing him, because otherwise, why wouldn't he have said something? But that would be a stretch. I mean, I would acknowledge that would be, I wouldn't even try and make that argument to say that silence when there's absolutely no discussion about any of these topics. I wouldn't argue with a straight face that would be enough, that you could just speculate that, well, by implication, you can say that he obviously decided to keep his attorney.
Okay, with that quite sensible concession made, let's back up to Friday. What about that period of time post-invocation on Friday? We have silence there, don't we? I mean, he's basically told, enough out of you, be quiet, we're not doing this now. And then after that, he is in an enforced silence, but substantive matters continue to be handled.
Well, I think to the extent there was any substantive matter, it was just the limited issue about the court articulating its ruling on Wood's unavailability, which again had already been argued before the unequivocal assertion. So basically at that point, to the extent that anything happened during the time frame where the court had indicated that it wasn't going to consider it, it was just the formal ruling that the court was announcing. And I guess what I would urge this court, I think that as the Court of Appeals panel stated in its opinion, this wasn't handled perfectly, but I think these situations, this is where reality again comes into play, and the district court judge is obviously the only one. None of us were in the courtroom. I think there has to be some recognition of the fact that a district court judge who is sitting there on the bench and not only hearing the words, but seeing the body language and seeing the way things are happening, has a better idea in this situation of, is this defendant truly asserting his right to self-representation in the sense that he wants to proceed pro se without the assistance of counsel and advocate as his own attorney, or is this somebody who's just frustrated in the heat of the moment because right here or right now his attorney is not arguing in lockstep with what the defendant would have him do? And I know that I find often, not only in reading trial transcripts for work, but oftentimes if I'm reading a newspaper account or a magazine article, I'll read words that just looking at a piece of paper don't seem to make sense for me. And I'm trying to figure out, how does this argument even track? What's this person even saying? But then I end up seeing a recording of that exact same interaction. And even though the words are exactly the same as what I read on a piece of paper, the context becomes a lot clearer. And I would argue that in this situation, the district court judge needs some level of deference to the fact that he was there. He was able to assess best whether this man was truly requesting self-representation or was simply frustrated that that particular argument was not going the way that he wanted. And then after giving the defendant time to think about it, both on Friday and then over the weekend, the defendant comes back into court on Monday morning, and they have these discussions in chambers. They go back out, they put it on the record. The defendant and his attorney both agree that counsel is going to argue these motions, that the defendant is going to withdraw his pro se filings. Again, I'm not denying that this could have been handled better. But as always is the case, a defendant's not entitled to a perfect trial.
Is there any reason why the rule for this shouldn't be the same as when a suspect is being interviewed by the police and says in the middle of the discussion, I want my lawyer here? We don't let the police keep talking. We stop and go forward. So is there any reason why this assertion of right, one which isn't subject, which is so important it's not even subject to harmless error analysis, from the U.S. Supreme Court. Is there any reason why the rule just doesn't have to be when the defendant says, I want to represent myself, you stop and do the inquiry, the appropriate inquiry? Because otherwise, aren't you just fiddling around? In other words, you don't have the prophylactic effect that our rule with police has in that other context.
Off the top of my head, I think the one response I could give with respect to why that stringent a rule might be impractical would just be, think of the implications on how that could occur throughout. A defendant could invoke that 100 times during the course of a trial. He could invoke
Well, you can't do it during trial. The rule.
Well, it is a slightly different
and
test.
I've never figured that out. I can't figure out why it's structural error, but the right goes away somehow. I mean, I think we've just imposed a practicality. I understand that in pre-trial, yeah, you could interrupt a lot of things, but
right, and I think that even at the pre-trial stage, I just don't know that that's the most. If there's a suppression hearing where you've got 3 witnesses and 200 pages of testimony, if on every single page or after every single question that's asked, the defendant decides he's not happy with the way his attorney phrased his question, I want to represent myself. Well, then do we each time, 200 times in the course of a proceeding, do we have to go back through the same checklist? I think that, again, my position would be in this case, we didn't ever get to that final need for Judge Magana to do the checklist and go over that with him, because before it ever got to that point, the defendant did clearly, I would argue, clearly signal that he had withdrawn his request for self-representation, that he did want to proceed with Mark Sievert representing him. And so again, while I don't think that he had to reassert the right once he had asserted it, I think that once he had asserted it and then withdrawn that assertion, then what the court did was appropriate. I know that I am far out of time. I am perfectly willing to submit the other issues on the brief.
Counsel, I have one quick question on another
Sure.
issue. Why not just give the defendant access to his own computer?
They did. That's the exact offer that he was made. You can go look at everything that's on those computers and phones. You just can't have them because they are being held in connection with this other case. But you can go look, knock yourself out, look at all of this. And he specifically turned it down. And I would point out that
He wasn't going to be allowed to do it by himself. It was going to be counsel, right?
Through his attorney.
Yeah.
And so I think that's key for 2 reasons. One is that it shows that he was given that opportunity and rejected it. The other point that I want to make
So
is
the state wasn't, your point is the state wasn't throwing hurdles up in the way of his access.
correct, neither the state nor the court. And then the other point that I wanted to make on that issue is that in his petition, and again today, counsel argues, well, the Court of Appeals opinion ignores the fact that I had requested a Van Cleve hearing. Well, 2 things. First of all, there wouldn't have been a need for a Van Cleve hearing if the defense hadn't rejected the offer at the time of trial. Second of all, when you look at that Van Cleve motion that the defense filed, that motion didn't allege a Brady violation. That motion did, the only reference that it made with respect to the computers and phones was an argument that counsel was ineffective with respect to the computers and phone. So the Van Cleve motion didn't say this court should remand, that the Court of Appeals should have remanded it to determine whether a Brady violation occurred. It was to argue that counsel was ineffective for somehow not gathering this information. I looked through there again yesterday, and unless I simply lost the ability to read, I didn't see the word Brady anywhere in that motion. So first of all, I think even if it had asked for a Brady hearing, for a remand for Brady purposes, he had already been given the opportunity at trial and very affirmatively said, no, I want to start the trial. I don't want to do that. So he had his opportunity, he turned it down, and then in the Van Cleve motion, he didn't assert Brady as a basis for remanding the case. Our position is that none of the issues that the defendant raises merit relief, and so we would ask that this court affirm both the Court of Appeals and the trial court.
Thank you, counsel.
Please the court, I would submit that the state is missing the point. He asked to represent himself on Friday. Let's look at the record. When the judge asked, and the judge originated this idea, when we're calling this gaming, the judge initiates the idea that he can't respond. He says, You either have Mr. Sievert argue this case, or are you representing yourself? That's the first time it comes up. He says, I'll represent myself if that is the choice. I will definitely. And the court asks, you're seeking to have Mr. Sievert taking off the case. If those are my options, then yes. What are you asking, Mr. Bunyard? And here's what he says. I'm asking to be heard right now. Not Monday, not some other point. And the court says, about what? And Mr. Bunyard says, about what we're having the hearing on. I have some information that they've given you information that's not correct. This is about him representing himself then. Not on Monday, because these motions are being heard and the motion about Ms. Woods is heard. He wants to present his side of the case. I mean, that's the point. So when we're talking about Monday, that's wonderful, but we say that it's been violated anyway, but what had to happen was then. And then when we're talking about Monday, let's remember the last thing that happens in court about this on Friday. The last statement of the court to Mr. Bunyard is, Mr. Bunyard, we're not addressing this matter further, period. Not today, not further today, we're not addressing it further. So when there's supposedly some meeting of the minds over the weekend, frankly, there's nothing on the record that says that, by the way, that he changed his mind, just that he's going along. And as Van has said, you just can't, going along is not it. And when this request is made, it's made. And we can all read things differently, I guess, but I don't know what body language we need to say that I want to deal with this now. I want to present this information now, represent myself now. What body language changes that? It doesn't. The whole thing about gaming, I guess, I don't see that here. He's asking his attorney to do things that are not happening. Justice Breyer, Mr. Ivey was the victim in the other case, the case where the computers were seized in. The case I represented Mr. Bunyard on at the district court level. He never asked me to be removed. He never raised motions about my competency. He didn't game the court then. I guess he was satisfied. He wasn't satisfied with Mr. Sievert. Whether that's right or wrong, I'm not here to argue. But he wasn't gaming the court. And in fact, when the court itself is the entity that raises the issue, do you want to represent yourself? I guess maybe the court's gaming him. I don't know. It's like, was that what you want? And Mr. Bunyard says yes. Maybe to the court's surprise. But once that yes is made...
I think the judge got more than he bargained for as a response for that.
I think he did, Your Honor. But once he said, yes, I do, and then they take a recess, as you'll remember, and then when he comes back, he said all this about I want to represent myself now, before the short recess. And when he comes back, he says, I want to represent, he says, for the record, I want to represent myself unequivocally. That's after his consultation with counsel. And then it goes on, put something in writing, we're not going to deal with it further. I don't think this record could be any clearer. I think a constitutional violation took place. Was it smart? I'm not saying that necessarily. Dylann Roof got to represent himself in his capital trial in South Carolina. That wasn't very smart when he had the best lawyers in the country, but the court found that was his right. And it was Mr. Bunyard's right on Friday to represent himself, and that right was denied.
Counsel, can you refresh my recollection on what your position is on Friday? At what point should the judge have done something, and what should it have been?
When they had the conversation, I think it was fine for the judge to say, let's take a breath, talk to your lawyer for a minute. I don't have no problem with that. But when he comes back then, after that consultation, and the first thing he says is, I want on the record, I wish to represent myself unequivocally, that's it, we're done. Then there needs to be a hearing. A FREDA hearing, or whatever form it should take, and that's the obvious guideline for this, but a hearing about him representing himself. That, I don't see the word unequivocally as equivocal, but that's me, I guess. It's pretty clear what he is saying. And at that point, time out. We're done for whatever we're doing that day until we resolve this issue. And Mr. Bunyard made it clear prior to that what he wanted to address as his own counsel were these motions. I want to be heard now. I want to deal with what we're dealing with in these motions. Clearer than that, I don't know what Mr. Bunyard could have done.
All right. Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. We now turn to the fourth case on this morning's docket. Case number 113675, Central Kansas Medical Center, DBA St. Rose Ambulatory and Surgery Center, v. Stanley M. Hattisall, MD, et al.
May it please the court, Mr. Chief Justice, KJ Wall appears on behalf of the petitioners, Great Bend Regional Hospital and Central Kansas Family Practice. I'd like to, if the court's so inclined, reserve 3 minutes for rebuttal. Chief
3
Justice.
minutes is granted.
Thank you, and I'm going to do my best to split my time equally with counsel for Dr. Hattisall as well. So around the 6-minute mark, I'll try and wrap up and cede the remainder of our direct time. By way of background, this case originates from Barton County, and it arises from an employment contract between Dr. Hattisall and Central Kansas Medical Center, or CKMC. Dr. Hattisall subsequently left the employment of CKMC and joined Great Bend Regional Hospital. In turn, the former employer, CKMC, sued under the non-compete provision of that employment contract and joined our clients, Great Bend Regional Hospital, under a tortious interference with contract theory. Ultimately, the district court found that that contract was unenforceable and violated the corporate practice of medicine doctrine under the precedent of this court in Early Detection Center. The Court of Appeals reversed that, and in doing so, and into my argument, committed legal error by applying an expanded, extrapolated version of this court's holding in Weiss, when under the facts of this case, Early Detection Center really does control the outcome of the proceeding. And the reason why has a lot to do with the corporate organization and structure of CKMC itself. As the Court of Appeals recognized that CKMC isn't really an ambulatory surgery center, it's a former hospital that's comprised of 8 separate independent divisions that are providing medical services to the community. One of those divisions does contain a same-day surgery center. However, Dr. Hattisall was employed to provide family medicine services at an unrelated clinic for an unrelated division. It had nothing to do with the ambulatory surgery center or the license that that surgery center held. And absent any sort of nexus between Dr. Hattisall's professional services or the contract and that licensed ambulatory surgery center, what are we left with? Nothing but a general corporation, CKMC, that employed Dr. Hattisall to practice medicine. And those facts are no different than Early Detection Center. And it's a violation of the corporate practice of medicine.
Where does that doctrine come from?
Well, it originated in common law, but I think over...
Well, it's a judicially created rule, right?
Correct. That's correct.
What is it about the judicial power that allows a court to engage in the regulation of occupations like that? I mean, I'm questioning really the validity of the corporate practice of medicine doctrine from the get-go.
Gotcha. I can't explain. There was obviously a public interest motivation behind it. Where the authority itself comes from, I'm not sure. Fortunately, that doctrine is now inextricably intertwined with legislative enactment.
Is that true in this case? In other words, if that doctrine goes away, is there anything in statute that would prohibit the enforcement of this contract?
Yes.
What is that?
Under the Kansas Healing Arts Act, individuals cannot practice medicine without a license.
But that's not the claim here, is that an individual was practicing without a license, is it?
Right. I should say that only an individual that is licensed can practice medicine. And in this context,
A corporation isn't a person here?
correct. That's exactly right.
In contrast to some other law.
Well,
Right, but by directing and controlling the agents, it is in effect practicing medicine. And there are provisions within the Kansas Healing Arts Act that carve out limited exceptions to the corporate practice of medicine for teaching hospitals,
Right.
teaching schools.
But I guess my question's more broad than that, which is I'm looking for a place in statute where the legislature has codified the ban on corporate practice of medicine that was judicially created, and I don't see it.
Yeah,
It just is silent on
you're
that.
not. There is no statute that codifies it directly. But
So,
what it
so
does,
nothing in statute says that this arrangement is illegal. It talks about other arrangements that are specifically codified as being legal, but it doesn't. I can't find anything in
Yeah.
statute that
Yeah.
would prohibit this.
It's a common law doctrine that the legislature had the opportunity to overwrite, but did not. Instead, worked around it because it's necessary to have a comprehensive regulatory scheme.
But for you to prevail, you have to have as the baseline that common law rule. Without that baseline, it's like, the whole rug's being pulled out from under you. Isn't that right?
I don't know that the whole rug is. I just don't know how you can give effect to those statutory schemes, the Professional Corporation Act or the provisions of the Kansas Healing Arts Act, and do away with the doctrine entirely because they implicitly endorse.
They might be rendered somewhat superfluous. I could understand that argument. Is that what you're saying?
Yes, yes. And I think that the court would want to construe the legislative enactments in a way that would give them meaning.
It's more than superfluous, though, isn't it? Because didn't you say they legislated around them? They legislated with the assumption that the doctrine was in place, in other words.
Correct.
Legislated and regulated with the assumption that the doctrine was in place.
Correct.
So isn't it your argument that the design of the statutory and regulatory environment was affected by the assumption that that doctrine was solid?
Yes.
Okay.
Yes. That
it's
is,
more than superfluous. It's not just that those statutes and regulations, some of them might be rendered superfluous. It also communicates something about the assumption of the legislature in doing the legislating it did.
Absolutely.
Okay,
Absolutely.
And maybe I missed something here because I thought you started with the premise that only licensed individuals could practice, even if we accept corporation as an individual. The only mechanism for a corporation to be licensed is under the hospital licensing statutes. Isn't that correct?
Well, a general corporation,
Right.
correct. The Professional Corporation Act, however, allows a professional corporation to practice medicine. And the reason why that is allowed, because then it does become a licensee by de facto and has to get approval through the Kansas State Board of Healing Arts. And then they have jurisdiction over the entity and the individual practitioners. So it's that regulatory safeguard that Professional Corporation Act reinforces part of this regulatory scheme designed to protect the public. The problem, I think, with the Court of Appeals argument is that you unwind this perfect fabric of protection for the public between the corporate practice of medicine, KDHE regulation, and the Kansas State Board of Healing Arts. Because here you have a hospital that could have been fully regulated in every aspect by KDHE. When they abandoned that license and focused only on one division, a surgery center, that's the scope of KDHE's review, control, and jurisdiction over this entity. It doesn't have authority to regulate these other 7 divisions. So it's up to the Kansas Board of Healing Arts. Well, the Kansas Board of Healing Arts cannot regulate and exercise its full authority over a general corporation that's not a licensee, which is the very reason the Professional Corporation Act exists. Will allow a professional entity to practice medicine because that brings it into the jurisdiction.
If we didn't have the judicially created doctrine against corporate practice of medicine, then the legislature would be free to debate and decide on those policies, right?
If you didn't have the corporate practice of medicine, the legislature could subsequently expand the jurisdiction of
Yeah, they could
the
do
Board of
whatever they
Human
wanted. I mean, presumably within constitutional limits.
Yeah, absolutely, they could have. Just like they could have abolished the doctrine.
And that's my
subsequent-
question, really, is where is this policy debate more properly located? I mean, should a court-made doctrine sort of short circuit that full public policy debate in the legislature?
Well, I think the public policy debate has been had, which is why we see the creation of the Professional Corporation Act and the Kansas Healing Arts Act, which were developed subsequent to this court's adoption of the prohibition. The legislatures addressed it. And between the Professional Corporation Act and the Kansas Healing Arts Act, coupled with the common law doctrine, they've got everything covered. But when you have a general corporation practicing, that's when we have a gap in the regulatory scheme.
That's where the common law has been taking care of it up till now.
Correct. I want to give my colleague time as well, but answer any additional questions or upon a rebuttal. Thank you.
Thank you, counsel.
May it please the court, Stephen Netherton on behalf of Dr. Hadasol, and I would also like to reserve half of the 3 minutes for rebuttal, Your Honor. I would like to go back to Justice Stiegel's point about where the doctrine originated in common law to address a public policy issue, as have other doctrines to enforce certain business transactions, one even that's present here, enforcing non-compete covenants. And the boundaries around permissible non-compete covenants is another doctrine found in common law that draws boundaries around what kind of non-compete covenants are permissible.
That falls within one of our sort of traditional slices of the common law, contract law. But regulation, I mean, do you agree or disagree that regulation of an occupation doesn't really fall into the traditional ambit of common law, does it?
My view, Your Honor, is they both stem from the same thing, and that is public policy. Here, the public policy being the provision of medical services by licensed or unlicensed individuals or entities in Kansas and many other states has been prohibited against corporations, with the exception of, in Kansas, hospitals. And here, in this case, the problem arose when an entity that is a corporation, structured as a corporation, ceased existing as a hospital, relinquished its hospital license, thereafter employed Dr. Hadasol to provide family medicine services at that time at a clinic that was off-site from its main facility. And in all ways, that entity really continued to act like a hospital when it no longer held a hospital license.
Counsel, I have a couple of questions based on the court's journal entry of judgment, the district court's journal entry. Was we've got the contract here. It's dated July 30, 2012. Was there any gap of time between when this was signed and when your client started to work?
I'm sorry, I'm misunderstanding the...
Was the contract signed very long before your guy started to work in Great Bend? I couldn't find, I don't look deep, but I don't have it right near me.
And truthfully, Your Honor, I could not tell you exactly with specificity to answer your question what the dates of time were between the start date in the clinic versus the time of the execution of the document. It sounds like that's what your question is asking for.
That's what I'm asking. Okay, so now I'm looking at paragraph 10 of the journal entry. It says, beginning in January of 2013, your client became a member of the ambulatory surgical center by virtue of having privileges. Is that date accurate? You don't have that, and that's not controverted, is it?
I don't believe it is, Your Honor.
Okay.
I don't believe it is.
And then the end of that paragraph, it says that your client didn't recall ever using the privileges. Now, there's probably no dispute about what he remembers or not, but is it controverted whether he ever used the privileges?
I'm trying to think about whether the plaintiff at that point controverted that. They asserted that the privileges did exist. I do not recall them controverting that fact about the exercising those privileges. And for clarification, the privileges we're talking about were privileges to perform pre-surgical evaluations of patients in connection with the ASC. Now remember though, that what is the issue in this case is the contract for Dr. Hadasal to provide family medicine services for CKMC and the post-employment covenant, the non-compete covenant, when he decided after his contract expired to provide family medicine services elsewhere. I only mention that because it doesn't seem to bear much on that issue what his particular privileges were as relates to the ASC and whether he exercised those privileges. What he was ultimately sued for was practicing family medicine services elsewhere
For a
after his
competitor,
contract expired.
across the street.
Across the street, exactly, Your Honor. And that point is not controverted.
It's a non-compete enforcement action with a snag.
Sorry?
This is a non-compete enforcement action with a snag.
With the snag, yes, Your Honor. And if I may conclude, Your Honor, I see I'm out of time, but if it,
I'll grant you 60 seconds.
Thank
That
you, Your Honor.
Enough time?
What really happens in this case is that this was a problem, as I said, of CKMC's own doing when they relinquished their hospital license but continued to practice as a hospital. Hospitals can, under 65-425A, operate clinics, family medicine clinics being one of them. CKMC could have avoided this problem altogether by two avenues. One, they could have taken, after they relinquished their hospital license, they could have taken their family medicine clinic where they were employing Dr. Hadasal and structured it separately as its own professional LLC or professional association where there is no problem with the corporate practice of medicine doctrine whatsoever, and then move forward with the ASC and other divisions on the one hand, and then this clinic with Dr. Hadasal being employed on the other hand. Or what they could have done, in light of the Early Detection Center versus Wilson case, seeing that that was on the books, and knowing that they were a corporation and they had just relinquished their hospital license, CKMC could have reorganized as a professional LLC or professional association, and that would have helped them avoid a lot of these problems. But we're here today because of choices that were made regarding this professional organization's structure, but in light of the court's precedent in Early Detection Center and in St. Francis, and no case has been brought forward by the plaintiff showing that ambulatory surgical centers that are corporately owned are exempt from the corporate practice of medicine anywhere, including in Kansas. The non-compete provisions here are void.
But nobody saw fit to challenge them until there was a lawsuit over a non-compete.
Beg your pardon?
But nobody saw fit to challenge the setup until there was a lawsuit over the non-compete.
That's how precedent is set.
Kind of a gotcha. Yeah, okay.
Any further questions? Thank you, counsel.
May it please the court, opposing counsel. My name is Sam Blatnick. I represent Central Kansas Medical Center, doing business as St. Rose Ambulatory and Surgery Center. There is a structure in place, a highly regulated structure in place for entities and facilities that operate ambulatory surgical centers. Chapter 65, Public Health Act in Kansas, requires entities seeking to operate a medical care facility, including an ambulatory surgical center, to apply for and receive a license. That statute then defers regulatory power over both those facilities and applicants to the Kansas Department of Health. Specifically, Chapter 65, 429 provides that the applicant and the physical facilities of the medical care facility must meet the requirements under this act. In this instance, as early as January of 2011, 3.5 months before the entity at issue here went from being a hospital to an ambulatory surgical center, Central Kansas Medical Center was in discussions with the Kansas Department of Health. The Kansas Department of Health was fully aware of exactly what Central Kansas Medical Center wished and intended to do. The Kansas Department of Health blessed the structure at issue by issuing the license. It blessed the structure at issue thereafter each year.
Well, KDH&E can't change the statutory definition ambulatory surgical center, can it?
No, it can't, but it is entrusted with, under Chapter 65 of enforcing and imposing the statute, and then the regulations.
We don't defer to the agency's interpretation of the statute, do we?
No, you do not defer, well, you defer under operative construction to its application of the statute, not the legality of construction of the statute itself. And here, the interpretation of the statute that the Kansas Department of Health undertook was to analyze the structure at issue and to bless it.
But we don't owe any deference to that blessing, do
No,
we?
you review the ultimate legal decision de novo.
So how is it that the family practice clinic fits the definition of an ambulatory surgical center under 425F?
Well, it doesn't, but this is where there is a disconnect here. Dr. Hadasol, pursuant to the employment agreement at issue, applied for and received medical staff privileges. He was part of the medical staff of the surgical center by virtue of his family medicine specialty. That is what he put on his application. Thereafter, the record is undisputed that he performed pre-anesthetic consultations of patients that received surgery in the surgical center.
He was authorized to do so. He had privileges to do so.
No, he actually testified that he did in fact. He analyzed patients for anesthetic preoperative reasons. He did not actually perform any surgical procedure. He said he did some small laceration repairs, if memory serves.
Okay, counsel, when my question to your colleague, opposing colleague, about paragraph 10, do you controvert then the district court's finding in the summary judgment order that says that the doctor did, he says it does not recall ever using the privileges. I don't care what he remembers or not, but do you controvert that he used those privileges?
My recollection of Dr. Hadasol's testimony was that he did in fact give preoperative anesthetic analysis to patients receiving surgical care in the surgery center. And he did so by virtue of his member of the medical staff of the surgical center.
Okay, let me ask you just a couple other questions about this summary judgment order. Paragraph 8 says that the license for operating the ASC was issued to CKMC. Is that correct?
CKMC doing business as St. Roche.
I don't care about the doing business part. The license goes to this general corporation, Central Kansas.
The license goes to a corporation and a facility that is then licensed.
Right. I understand that you've got a facility license, but the holder of the license is Central Kansas.
Yes.
Okay.
And by virtue of holding that license, it becomes a medical care facility and a healthcare provider under Kansas law. And we believe, therefore, St. Francis applies, and specifically this court's previous statement that the hospital at issue there was both a healthcare provider and medical care facility, and that distinction was crucial in the court's determination in the St. Francis decision.
So when the contract was entered into on July 30th, 2012, and he's not associated with, according to the district court, he's not associated with the ambulatory surgical center until January of 2013. That's when he gets his privileges over there. How is this contract not void when it's entered?
Well, the contract does not provide that Dr. Hadasol will not work in the surgical center. The contract says he's going to provide family medical services or other services customarily provided by similar physicians, and it says he's going to work at the Joe's Clinic or elsewhere as agreed between the parties.
But he didn't do that.
No, but he could have. On day one, Dr. Hadasol could have gone right to the surgical center. That isn't what happened under the facts here, but that could have happened. And for the agreement to be illegal, it has to require illegal conduct. So in the present instance,
Isn't the provision of family medical services illegal conduct?
No.
It sounded like you admitted that.
Family medicine doctors in the state of Kansas do surgery. Family medicine doctors do a whole range of things. And Dr. Hadasol actually applied for surgical privileges in the ambulatory surgical center.
Are you saying that nothing that he did was unlicensed? Because I heard you say earlier that you were essentially conceding that the clinic did not fall under the ambit of the ASC license.
It does. If I said that, I misspoke. It does.
Well, let me get back to that question, because I think the question I asked was, how is it that the clinic falls under the definition of an ambulatory surgical center under 425F?
Well, because KSA 65429, in issuing the license, the Kansas Department of Health is empowered to review and analyze both the applicant and the facility.
We already established that we aren't going to defer to KDH&E's determination. I'm looking at the statutory definition.
The statutory definition
which requires
facilities.
A facility that's equipped and operated primarily for the purpose of performing surgical procedures.
Yes, and those facilities include buildings, equipment, and the medical staff, including physicians.
So how was the family practice clinic equipped and operated primarily for the purpose of performing surgical
The family medicine
procedures?
clinic was not part of the facilities as the definition of the.
Okay, so it was unlicensed then.
The clinic itself was not, but the entity operating it was. And
But the license that the entity operating it held was not broad enough in scope to cover the services offered through the family practice clinic.
Yes and no. Dr. Hadasol, as a family medicine practitioner across the street, could go over and do pre-anesthetic consulting services to the ASC. Okay. So as an individual, he could be part of that, even though the physical location across the street wasn't. And in fact,
including the things he did in that physical location.
Yes.
Okay.
And in fact, the pre-anesthetic consultations that Dr. Hadasol gave are required under the Kansas regulations for ambulatory surgical centers.
It makes it, maybe I just don't understand this, but it makes it sound, you make it sound like it's legal for Central Kansas Medical to contract with a doctor, put in the contract that we might send you over to an ambulatory surgical center, but we don't have to, and then have them work somewhere else that's not associated with the ambulatory surgical center all day and all night, and that's legal under the this common law doctrine.
I'm sorry, legal or under the common law doctrine articulated by the appellate court or the previous common law doctrine?
The previous common law doctrine, before it was expanded.
Under St. Francis, if the entity at issue is a healthcare provider and or medical care facility, then yes, I believe it would be. As opposed to, for example, Early Detection Center, which was a non-licensed, non-regulated, single-purpose, non-invasive vascular testing center.
Isn't it more accurate or maybe more precise to say that St. Francis's holding was that when a corporate entity has its own license, that services offered pursuant to that license do not violate the common law ban on corporate practice of medicine? So the question then is, did these services fall within the ambit of the license that your client actually held?
Dr. Hadasol did in fact perform services pursuant to the employment agreement that fell within that ambit.
And he also performed services that fell outside that license?
Yes, he did.
So are you breaking the law when he's performing services outside of the ambulatory surgical center?
I don't believe
is it enough
to
bless this agreement? Because they stepped foot occasionally in the ambulatory surgical center. And is this then a fact-intensive discussion?
The policy concerns that underlie this doctrine are concern the imputation of corporate motives upon physicians such that they will not carry their duties in the manner in which they are entrusted and are supposed to do. And I would posit that by virtue of the entity itself being regulated, the entity paying into the Healthcare Stabilization Fund, and having to proffer its proof of insurance, for example, to the KDHA under the statute at issue here, that the concerns are not implicated, because what you have is an entity that is being monitored, an entity that is being controlled, an entity that is paying into the Healthcare Stabilization Fund, such that the concerns of a lack of patient care or miscare are not implicated. And in fact, Dr. Hadasol had every opportunity to testify in this case that the corporate structure here, the corporate structure being a non-for-profit run by the Catholic Health Initiatives, somehow improperly impacted his decision-making or his motives or any other part of his practice.
Counsel, along those policy lines, would you agree that if the state of Kansas did not have a common law corporate practice of medicine doctrine, that would resolve all of this and that you would walk away with a valid contract?
Yeah, yes, Justice Steele. And in fact, going back to a question that you asked earlier today, states are all over the board on the corporate practice of medicine doctrine. It is a very unique doctrine where it exists and that embodies the policy and concerns of each state. Many states do have statutes. The Kansas legislature has had the opportunity to pass one if it felt it was necessary, and it has not done so.
And since we have it, you're trying to fit your argument into St. Francis Regional Medical Center.
We believe that the language used by this court in that decision applies here. This is where there's a fundamental distinction between my client and the appellants. The court in St. Francis said that they declined to extend the facts of Early Detection Center. And you've got to look at this in context. Early Detection Center was entered in 1991. The previous case, the Zales jewelry case, was 1956. So we have a 4-decade lapse. And a lot changed in that period of time, obviously, in the practice of medicine. And Early Detection Center was not an optometrist trying to sell glasses like Goldman and Zales. It was not a dentist in the back of a building. It was a single-purpose entity. And in Early Detection Center, the court said that this is a general corporation because it doesn't pay into the Healthcare Stabilization Fund, and it doesn't do so because it's not a healthcare provider. That's not the facts here. Fast forward to 1994 in St. Francis. This court said we declined to extend the holding in Early Detection Center. So that's where we're coming from, is that Early Detection Center itself is an outlier, not this general umbrella. And the facts here are certainly distinguishable from those in Early Detection Center, where we had a single-purpose, for-profit entity. We have a general-purpose healthcare provider that provides all services other than overnight stays and ambulatory care. By ambulatory care, I mean emergency care, I apologize. And wanted to close down and tried to close down. This structure was born out of a compromise to provide healthcare, to provide as much healthcare as could be provided in the state. And that's why, and I made this argument at the appellate level, a ruling that the structure such as this is not legal, a ruling that the blessing of the regulatory body at issue here is not legal, is going to limit healthcare in the state. And I understand the importance of making sure that the healthcare that is provided is good and the motives underlying it are proper. But as we see here, under the structure issue here, those concerns weren't implicated. They just weren't.
Do you think we have a controverted fact that needs to be resolved about whether the doctor actually used the privileges at the ambulatory surgical center?
Having deposed Dr. Hadasol and having cross-examined him at trial, it's my recollection, and quite clearly, that he did in fact. And if the record is,
all I can do is deal with the district court order here, and I'm trying to see whether that isn't a material fact as to whether your contract is good or not, whether he was actually doing, in my mind, a material or significant amount of work for the ambulatory center.
If that is, I believe, a material fact in this case, and it's a material fact because if you look at St. Francis, this court said to hold that the contracted issue was invalid there would prevent hospitals from doing what they've done for years and what they need to do. That's the same here. Dr. Hadasol was employed to provide required services.
Let me tell you what I'm struggling with. It seems like it wouldn't be a material fact if your earlier answer to me was right, that it doesn't matter whether the doctor is working a little bit in the surgical center or a whole lot in the surgical center, as long as you put in your contract that he can walk over there and work whenever you want him to. You see what I'm getting at?
No, I understand what you're saying. I also understand the concerns that you're implicating. But I think the baseline we have to start from is that if you are an entity that has an ambulatory surgical center and you're offering other clinics, there is a possibility that those doctors may provide treatment in that ambulatory surgical center. For candidly, any of the remaining clinics. just because by virtue of surgery, a surgeon requires and calls upon other practitioners, both physicians and physician's assistants and the like.
Counsel, I see you're out of time. We've taken up a lot of your time with questions. Would you like 30 seconds to wrap up, or do you think you've made your points?
I would take the 30 seconds, Chief Justice Ness. In this particular instance, we have a doctor who, for only purposes of trying to invalidate a non-compete, he has not reported himself to the Kansas Department of Healing Arts, claims that he engaged in the improper and unlawful practice of medicine for several years. In Weber v. Tillman, this court cautioned against seeking loopholes to invalidate contracts. That is exactly what the appellants are trying to do here. Having received compensation from St. Rose, having received patients from St. Rose, having received training from St. Rose, and having on the way out misappropriated confidential information from St. Rose, Dr. Hadisall went across the street to its primary competitor, while his wife also was involved in that as an employee of St. Rose still, and now seeks to find loopholes to invalidate an agreement that for years he recognized as valid, and again, solely for purposes of this litigation.
Thank you, counsel. My understanding is you are splitting your 3 minutes.
Yes, Chief Justice, that's my hope or intention at least. Thank you. I just want to address any questions the court have, but barring that, 2 points. I think the argument that opposing counsel is making is he's trying to place all medical care facilities on equal footing, and I think the point Justice Stegall raised is that that's really not correct. Under 65-425, a medical care facility is only defined by its constituent parts: a hospital, an ambulatory surgery center, or a recuperation center. That same statute then defines each of those facilities. It has a definition of a hospital, which says that it can be organized to have physicians 24/7 to treat a wide variety of conditions. In contrast, subsection F defines an ambulatory surgical center in a much more limited fashion, and to that extent, they don't all stand on equal footing. And
in fact, the licenses the entities get are different.
Absolutely.
They're licensed under the narrower portions of the statute, not under the broader portion of the statute.
That is correct. That is correct as well. And to that extent, to try and extrapolate them all on equal footing fails to give meaning to the legislative definitions under KSA 65-425. Also, to the point of the controverted fact, my recollection of the record is proposed findings of fact were submitted to the district court. I don't recall an objection to the factual basis in the questions that Justice Biles was asking earlier. And to the extent, even if he pulled some stitches out or on a rare occasion was at the ASC, our position is that's the scope of the protectable interest of the non-compete and not the prohibited portions under the corporate core practice of medicine doctrine. And he left employment to practice at a family clinic, which I would argue that it's not a material fact to resolving and reinstating the district court order in this case. Barring any questions, I will rest on that in the briefs. Thank you.
Any questions? Thank you, counsel.
I only have two, obviously very brief points to make. Point number one, I think should be made is the issue of whether to overturn the corporate practice of medicine doctrine is not before the court in this action. It was not requested by the appellant. In 1994 in St. Francis versus Weiss, the court could have overturned it, looked at case law from New York, Missouri, Nebraska, and Florida, and statutes from those states, and then also considered amicus briefs and chose not to overturn it. That issue has not been before the court in this matter. The second issue I want to address is to Justice Biles' point about whether there were pre-surgical evaluations actually performed. The citation to the record about that testimony, Your Honor, is on volume 16, starting at page 120, volume 14, starting at page 87. No, there's no evidence that Dr. Hadisall ever performed such evaluations pursuant to those pre-surgical privileges. unless there are any questions from the court, we request that the court reverse the Court of Appeals decision, reinstate the district court's entry of summary judgment.
Do we have any questions? Thank you, counsel.
Thank you.
We thank all three lawyers for your arguments this morning and this afternoon. The court will take this matter under advisement. That concludes this week's docket. Court is now adjourned.